Good afternoon. Welcome to the Analyst. Today we'll be discussing 5 newspaper articles from the Hindu and the Indian Express. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll be discussing today is related to green finance, that is financing of climate change. We'll be discussing the principles as well as the mechanisms of climate change finance. The second article is related to POCSO Act, as the Calcutta High Court has recently suggested the decriminalizing of consensual sexual acts between adolescents above 16 years of age. The third article is related to the questions which an MP can ask in the parliament. This is in reference to the Mahua Moitra Cash for Queries row. The fourth article is related to manual scavenging, the practice which is unfortunately still prevalent in several districts in the country. And the final article is related to criminal investigation. We'll be discussing a few case laws and judicial interpretation too. Coming on to the first article, this is related to green finance, that is financing of the climate change. This article suggests that more private sector funding is needed for financing climate change for adaptation and mitigation measures related to climate change. Historically, the West developed first, and that development came through industrialization. The Western nations, the European nations, they industrialized first. Now that process of industrialization, it led to some damage to environment also. For example, it led to emissions of carbon, which subsequently led to increase in the global temperatures, leading to global warming, climate change, etc. Now the article suggests that we need more finances to address the overlapping challenges of poverty reduction, climate change, biodiversity protection, etc. We need to shift from billions to trillions in terms of global investments. Now, to deal with this problem of climate change through the Paris Pact, the countries agreed that the rise in temperatures of the world, they should be controlled. They should not be more than 1.5 degrees Celsius to 2 degrees Celsius compared to the pre-industrialization levels by 2100. Now, to achieve those targets, developed countries are supposed to give some finances to the developing countries so that they can take both mitigation as well as adaptation measures, because the developing countries, they have some needs also. They need to take care of their developmental needs, they need to build infrastructure, they need to take poverty alleviation measures, etc. And they need to industrialize also. For that, financing support is needed from the developed countries. Now, why that money is important? As per the IPCC report, the global emission levels, they have to be controlled. They have to rise by not more than 43% from 2019 levels till 2030 to ensure that the Paris target of ensuring not more than 1.5 degrees Celsius rise in global temperatures, that is adhered to. Likewise, the Standing Committee on Finance of the OECD has suggested that we need at least $6 trillion to ensure that the NDCs are adhered to. NDCs are the nationally determined contributions which the countries come forward voluntarily and they pledge that they will be taking these measures to ensure that they are contributing to tackling the problem of climate change. They are ensuring that the net emissions that they are contributing to in the environment, that is not more. Likewise, the loss and damage needs for the developing countries, that is going to be $400 billion per year to ensure that it is taken care of. More climate finance is needed. Even the $100 billion per year of climate finance which was pledged by the developed countries, which was supposed to be given to the developing countries, even that has not been coming through. It was supposed to be done by 2020. But the OECD report has suggested that even in 2020, only $83 billion was given to the developing countries. And if we look at the track record previously, it was less than $50 billion in 2015. And this money is needed for both mitigation as well as adaptation measures which are to be taken up by the developing countries. Now, while giving this finance, which is supposed to be given by the developed nations, they are raising some concerns. What are their concerns? Let us look at that. They say that the historical emissions which were there when the industrialization happened in the West, It happened when there were no alternatives to the fossil fuel based energy sources. Therefore, they had to use coal based energy sources or fossil fuel based energy sources, and there was little understanding or consensus on the harm which was caused by the greenhouse gases. Therefore, they should not be the sole bearers of that historical responsibility. Also, they highlight that since 1992, about 57% of the global carbon dioxide emissions have come from the non-Annex 1 countries. The Annex 1 countries are the 40 rich and the industrialized nations, and the non-Annex 1 countries are all other countries in the world except those 40 rich and industrialized countries. And they also say that 70% of the incremental warming which has happened since 1992, it has happened due to carbon dioxide, sulfur dioxide and methane emissions, and most of it is coming actually from the developing nations. That is what developed nations argue. Now, bridging this adequacy gap, that is not the sole responsibility of the developed nations only, that is what they argue. And also there is a disagreement on the global stocktake. This global stocktake was supposed to be done in the Bonn conference, but it has not yielded results, and therefore there are disagreements regarding the finance which is supposed to be given by the developed countries, and also in terms of technology transfer, and they are shying away from taking up historical responsibility also. Now let us talk about the principles of climate finance first. Now, after the Rio summit in 1992, it was universally acknowledged that polluter pays principle should apply. That is, anybody who pollutes the environment, anybody who degrades the environment, he should be the one who should be held responsible, and he should pay the money to the people who are suffering that damage. Therefore, the developed countries, they industrialized first, they caused emissions, and therefore they should pay to the developing countries also. Also, another concept is common but differentiated responsibility and respective capability. As per this principle, there should be a differentiated responsibility. Although tackling the problem of climate change is a global responsibility, it is the responsibility of every nation. But the responsibility should not lie equally on the shoulders of all nations, because those nations who have developed first, who have emitted more historically, they should pay more. Therefore, it is a common responsibility but a differentiated one, and the capabilities to pay, they should also be taken into account. Therefore, the developed and the richer nations, they should contribute more in this fight against the climate change. Also, the additionality principle should be followed when we are talking about climate finance. It means that the developed countries, when they are taking up initiatives for example, infrastructure development in the least developed countries, etc., then that finance should not be considered as a climate finance. There should be no diversion of funding. The funding which was supposed to meet the developmental needs of the developing countries, that should not be taken into account when the climate finance is considered. Also, it should be adequate to ensure that the temperature rise is not more than 1.5 degrees Celsius to 2 degrees Celsius, and the developing countries, they are able to take both mitigation as well as adaptation measures. And the climate finance, it should be predictable. There should be a sustainable flow, and hence a pledge should be there from the developed countries, and that pledge should be in the form of multi-year pledges, and the cycles for the payment, they should be medium-term cycles to ensure that there is continuous fight against the problem of climate change. Let us discuss some mechanisms for the climate finance first now. Internationally looking, there is a provision of carbon credits. What does carbon credits mean? It means that if a country, if it is emitting more carbon than it is entitled to, then it can purchase virtual carbon credits from another country which is emitting less carbon than it is entitled to. This procedure came through the Kyoto Protocol, which actually started the climate financing mechanism. And there is also the clean development mechanism, as per which sustainable infrastructure, climate resilient infrastructure is supposed to be built in the developing nations, and also loans are also given to the developing nations at a concessional rate. And the adaptation fund is there, for which 2% amount comes from the clean development mechanism to the adaptation fund to ensure that adaptation activities can be taken up by the developing countries. and it is to be jointly implemented. That is the Annex 1 countries, that is the 40 rich and industrialized countries, they are trading carbon credits also. For example, if a country is emitting more carbon, then it can purchase carbon credit from another country. When we talk about climate finance and how it is managed, then there are two mechanisms. One is the Global Environment Facility. The Global Environment Facility, it was mooted through the Rio Summit and it came into force in 1994. It gives loans and grants to the developing countries. And there is the Green Climate Fund also. This Green Climate Fund was established after the 2010 Cancun Summit, and it is for the reduction of the greenhouse gases, and it also takes care of the adaptation related activities in the developing countries. Apart from the Global Environment Facility and the Green Climate Fund, there are two more funds. One is the Special Climate Change Fund and another is the Least Developed Countries Fund, both of which are managed through the Global Environment Facility only. And there is obviously the Cancun Agreement, through which the developed countries, they are supposed to give $100 billion per year to the developing countries. Nationally looking, when we talk about the climate finance in India, there is the National Adaptation Fund. This is administered by the Ministry of Environment, Forest and Climate Change, and the corpus is of 100 crores. There is the National Clean Energy Fund. This is financed initially through the carbon tax, which is imposed upon the use of coal as the energy source, and this is used for R&D purposes to ensure that there is more research and developmental activities in terms of the renewable energy. Obviously, there are other mechanisms like CAMPA funds, which are there to ensure that if a forest land is diverted, if there is cutting down of forests, then there is provisions that money has to be paid to ensure that there is an equivalent amount of forest also which is resurrected somewhere else, and there are disaster management funds. Also, the government has come up with the 100% FDI provision for the renewable energy under the automatic route. Now, what are some ideas to deal with this problem? One, we have to ensure that there is a more structured and targeted approach to deal with the problem of climate finance, and there has to be a clarity on the definition of climate finance. Because what do the developed countries do? They greenwash their finances. This greenwashing of finances, and it leads to the passing off of loans as the climate related aid to the developing countries. Another idea is the new collective quantified goal on climate finance. Here, there are quantifiable needs which are put into place for the developing countries, and there is a mechanism for their allocation also. This will eventually replace the 100 billion target. This is an idea as of now. The 100 billion target, which was there ever since the 2009 Conference of Parties in Copenhagen, which was supposed to be achieved by 2020, which has also not been achieved. And this NCQG will also act like a reference point for the climate financing needs of the developing countries before 2025. Apart from this, there is the New Delhi Declaration, which also acknowledges that $5.8 to $5.9 trillion will be needed before 2030 for the NDCs, the nationally determined contributions, and $4 trillion will be required for the developing countries to attain net zero emissions by 2050. And apart from that, obviously the private sector funding is also required as suggested by this article. The second article is related to the POCSO Act, as the Calcutta High Court has called for decriminalization of consensual sexual acts involving adolescents above 16 years of age. This is important in GS2 in the topic vulnerable sections and the laws related to them. Now, POCSO is the first comprehensive legislation in India for the protection of children under 18 years of age to protect them against sexual offences, sexual assault, child pornography, etc. It is administered by the Ministry of Women and Child Development. Before this also it was in news because a Kerala-based women's rights activist allowed her children to paint on her semi-nude torso, and in that case the court observed that the section 7 of POCSO, for it to come into picture, there has to be a sexual intent for it to amount to a sexual assault on the children. Now let us look at the features of POCSO Act first. This is a gender neutral law. It is applicable for a boy or a girl. Any person who is under 18 years of age can be a victim under the POCSO Act. and there is no time limit for reporting the abuse. That is, a child victim can report the incident of sexual assault after years of that incident also. And there is a provision that it has to be mandatorily reported. If there is no reporting, then it can lead to imposition of fine as well as imprisonment up to 6 months also. And it has inbuilt safeguards for the victims to ensure that the children's interaction with the criminal justice system, it is child friendly and they are not intimidated. What safeguards are there within the POCSO Act? For example, the child victim is not supposed to see the accused at the time of testifying, and the trial is supposed to be held in camera so that the child is not intimidated and he or she is not supposed to recount the horrors. And the evidence of the child shall be recorded within a period of 30 days of taking cognizance of the offence by the special court. The special fast track courts are also supposed to be constituted under the POCSO Act, and special PPs, special public prosecutors, are also appointed under the Act. And the completion of trial is to be done within 1 year from the date of cognizance of the offence, that is, when the court takes cognizance of the offence. And after this, there have been some amendments also. In 2019, the Act was amended. That is, more punishments were included for specific offences. That is, even death penalty can also be inflicted upon the accused if there is an aggravated penetrative sexual assault, if it is committed by the persons of authority, that is by the relatives, for example, or the people in authority, then it constitutes as an aggravated assault. Also, there is a provision for the levy of fines and imprisonment up to 20 years to curb child pornography too, and it amended the definition of child pornography. It reads now that any visual depiction of sexually explicit conduct involving a child, which includes photographs, video, digital or computer generated image, indistinguishable from an actual child, and an image created, adopted or modified but appears to depict a child. Now, interestingly, neither the IT Act, its section 67, nor the IPC, its section 293 contain the definition of child pornography. It has been included only in POCSO Act. Now, there were some POCSO rules also which were put into place in 2020. According to them, there has to be a mandatory police verification. That is, the police verification of the shelter homes, the children shelter homes which house children. There, the police has to verify not only the homes but also its employees also. Then sensitization training etc. has to be conducted for the employees, the staff of the shelter homes for children, and the children homes, they have to adopt a child protection policy also. A policy framework has to be put into place in line with the principle of zero tolerance for violence against children, and some support persons should also be appointed. Support persons are those persons who handhold the child victim throughout the procedure of the criminal justice system, throughout the investigation as well as trial. They render assistance to the child victim. Now, there are certain implementation hurdles regarding the POCSO Act. One, such abuse is on the rise. There are more number of cases which are registered, and the government claims that this is a proof that it is being implemented and more cases are being reported. But there are limited POCSO courts because special courts are supposed to be constituted under the POCSO Act. But as of 2022, only 408 POCSO courts have been set up in 28 states. And even there also they lack the special public prosecutors which were supposed to be appointed for the trials for the child victims. There are excessive delays in the trial of the POCSO related cases, and the maximum pendency is in Uttar Pradesh, which accounts for almost 75% of the pendency in POCSO related cases. There is a poor disposal rate. The POCSO related cases, the trial has to be conducted within a period of 1 year, but on an average it is taking about 500 days. There is a high acquittal rate also. 44% of the trials which are conducted under POCSO, they result in acquittals, and only 14% end in convictions. Now, this is not in line with the NCRB data. NCRB 2021 data says that 96% of the cases which are filed under the POCSO Act, there the accused was a person known to the child victim. If the accused was a person known, still the conviction did not happen. It resulted in high rate of acquittal. There is an absence of support persons. The Supreme Court has recently observed that in 96% of the cases related to POCSO, there were no support persons provided to the child victim, and there is a lack of awareness regarding the provisions of the POCSO among the general public, and there are some new challenges also. For example, due to the COVID-19 pandemic and emerging forms of cybercrime, for example, artificial intelligence being used to morph the images to produce more child pornography, etc., this is again causing hurdle in the implementation of POCSO. Now let us also talk about the age of consent, because the Calcutta High Court has suggested that the age of consent here can be considered up to 16 years rather than 18 years. The 22nd Law Commission of India report number 283 suggested that the age of consent should not be lowered. The government should not reduce the age of consent, as it will have a direct and negative bearing on the fight against child marriage as well as child trafficking. And it says that there can be some amendments which can be done in the POCSO Act, so that the children who are aged between 16 to 18 years who give tacit approval but it cannot be termed as legal consent, then there the cases can be treated differently. And it advised the courts also to tread with caution if the cases are related to adolescent love. For example, a study by UNICEF India has indicated recently that 25% of the POCSO related cases are actually due to romantic affairs. Where criminal intention may be missing, there also the courts may treat the case differently as per the Law Commission of India recommendation. And this will ensure that the law is balanced. There is a balance of equities and the safeguarding of the best interest of the child in such cases. Another issue is there is an incongruity between the Muslim personal law and the POCSO law. As per the Muslim personal law, the girl who becomes the age of puberty, she is able to marry, she can marry, and it will be a legal marriage. It is assumed to be 15 years of age. Whereas as per POCSO law, the sexual acts which are conducted between children of less than 18 years of age, they are not legit. Now, what can be the way forward for the implementation and for the better implementation of POCSO? One, we can have more policy interventions to meet the specific capacity constraints of a particular state. We should not go with a one-size-fits-all approach when it comes to the implementation of POCSO. Various social customs prevalent in various regions, in various states, they also have to be taken into account to ensure implementation. And POCSO courts, they have to be made functional, special PPs, they have to be appointed, and monitoring can be done by the high courts of the respective states. The evidence gathering can be done through a hybrid approach. That is, some of the recordings can be done through in camera. That is, evidence of the witnesses can also be taken through video trials. And uniformity in e-courts data should be ensured so that there is easy tracking of the status of the cases also. And periodic training should be provided to the police officers to sensitize them to ensure that there is no child harm. And comprehensive outreach program, a system should be put in place where the government engages with all the stakeholders in the society. For example, engagement with parents, with schools, communities, NGOs, even local governments, Panchayati Raj institutions, police as well as lawyers, so that the best interests of the child, they are always kept in mind. And we can obviously educate children too. The next article is regarding the questions that an MP can raise in the parliament. The context behind it is that MP Mahua Moitra was accused of taking a bribe from a businessman, Darshan Hiranandani, the CEO of Hiranandani Group, for asking questions in the parliament. This is important in GS2 in parliament and state legislature structure, functioning and conduct of business. Now, this is not the only case of cash for query scam in the parliament. Earlier also in 2005, there was another case for cash for query scam where 11 MPs were subsequently expelled from the parliament because through a Cobra Post operation, that is, it was an online news website, Through that operation, it was found that 11 MPs, they were taking cash in return for asking certain questions in the parliament. Now, that is not for us. Let us discuss the rules and procedures regarding the asking of questions by the MPs in the parliament. Rules 32 to 54 of the Rules of Procedure and Conduct of Business in the Lok Sabha determine the rules for the asking of questions, and also there are directions 10 to 18 of the directions by the Speaker Lok Sabha. Now, what is the procedure for asking of the questions? A notice by the MP who wants to ask a question has to be given, and that notice is to be addressed to the lower house's Secretary General, that is the Secretary General of the Lok Sabha. And the notice usually contains the text of the question, the official designation of the minister to whom the question is addressed, and the date on which the answer is desired, and the order of preference if an MP tables more than one notice of questions for the same day. Now, an MP can ask multiple questions also, but when it comes to asking oral questions, an MP can ask only one question in a day. For that also, an advance notice has to be given. An advance notice of usually 15 days has to be given. And while giving notice, an MP can give notice for asking 5 questions maximum in a day. Now, what are the ways through which the MPs can submit the notices of the questions? Either they can refer to an online portal which is provided to the MPs and they can log in into that portal for raising queries, or through the offline mode also in the parliamentary notice section they can ask the questions, they can submit their hard copies of the questions. Now, what is the role of speaker when the MPs are asking questions to the ministers in the parliament? The speaker, as per the rules of the house, as per the rules which are laid down for that house, determines whether those questions are admissible or not, whether they deserve to be answered in the parliament or not. Now, what are the conditions for the admissibility of the questions which are asked by the MPs in the house? One, it should usually be not more than 150 words. And it should not be in the form of arguments or defamatory statements, because defamatory statements that will damage the reputation of the minister in charge who is supposed to answer these questions. And they should not be raising larger issues of policy, because else it will be difficult for them to be answered. And it should not relate to a matter which is sub judice. That is, if a matter is under judicial investigation or it is undergoing trial, etc., or it is under the scrutiny of the courts or any tribunal, then it cannot be asked, or it is under consideration before a parliamentary committee. Also, that question should not seek information on matters which will impact the unity and integrity of the country. Now, what are different types of questions which an MP can ask? One, there are starred questions. The starred questions are oral questions. They have to be given 15 days advance notice before they can be asked. And the starred questions, their answers are oral. They are orally answered by the minister in charge. And supplementary questions can also be asked after the answer given by the minister in charge. For unstarred questions, the answers are given in the written format. Maximum 230 unstarred questions can be tabled in the parliament in a day, and there cannot be any supplementary questions which can be asked after the unstarred questions answer. And then there are short notice questions. The short notice questions should relate to the matters of urgent public importance, and reasons have to be given by the MP asking the short notice questions, that why it is so important that it has to be taken up urgently. And then there are the questions which are addressed to the private members, that is not to the ministers but rather to other MPs, and that the questions can be asked if that MP is particularly responsible for that particular department or that particular question. Now, what is the importance of raising questions in the parliament? One, it is an inherent and unfettered parliamentary right of an MP to ask questions, and it is also a parliamentary device to practice legislative control over the executive actions. Through this only the parliament exercises control over the executive, and it can be used to get information on the aspects of administration and government activity. It can be used even to criticize the government policies and schemes, also to encourage debates on the floor of the house, and it will throw light on the government lapses, etc. Also, it will push the ministers to take substantive steps for the common good. Coming on to the next article, this is related to manual scavenging. The Supreme Court has said that the claims of fraternity, equality and dignity among the citizens, it will remain a mere farce. As long as practices like manual scavenging, they are still at play, if a sizable section of the society is forced to enter sewers for a living, and for this living they die trapped in them even a decade after outlying of this inhuman practice of manual scavenging. The practice of manual scavenging was outlawed through the Act of 2013 also. This is again important in GS2 in the topic vulnerable sections and the welfare schemes related to vulnerable sections. Now, as per the report of Ministry of Social Justice and Empowerment, manual scavenging is still practiced. Only 508 districts in India out of the total of 766 districts have declared themselves free of this practice of manual scavenging. Now, what are the dangers related to manual scavenging first? This is a social evil. This is even perpetuating the social evil of caste system. This will perpetuate the practices like untouchability. For example, Article 17 of the Indian Constitution prohibits the practicing of untouchability, but manual scavenging actually perpetuates this in certain regions. And also manual scavenging leads to the emission of dangerous gases, and in that dangerous environment a human being enters, and in that toxic environment there are deaths also which are caused within sewers, because a person enters a sewer and cleans it from the human excrement, and that is a dangerous practice. It is dehumanizing also because it inflicts indignity upon the individual. This is against the very dignity of the individual. Why does it still exist? Because usually the operations which are related to scavenging, they are outsourced by the government departments. Cleaning of sewers, etc., they are outsourced by the public works departments, and no records are also maintained about the outsourcing at times. Therefore, the state government plays a huge role in the continued practice of manual scavenging. Also, when we look at it from the side of employment, this is considered as a livelihood opportunity also by some sections in the society, because there are entrenched generations, lower caste, etc., who see no escape from this practice, who have been doing this since generations, and they seek income. Having no other skill set, having no other means of livelihood, they are forced to do this for money, and there are often at times loan burden also, as observed by various studies, and that is forcing people to engage in manual scavenging also. Now, what are the steps related to manual scavenging to eliminate this practice which were taken up by the government? First, there was an Act of 1993. The Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act in 1993. This was to impose ban on manual scavenging. Then in 2013, after a Supreme Court judgment, the government enacted another act, Prohibition of Employment as Manual Scavengers and their Rehabilitation Act. This reinforces the ban on manual scavenging and also focuses on rehabilitation aspect. Then Supreme Court in 2014 observed that there should be some compensation also which should be provided to the people who have unfortunately died while cleaning sewers, etc. For example, one-time cash assistance should be provided to the people who are engaged in manual scavenging to ensure that they are able to start a new life. Houses should be constructed under Awas Yojanas, etc. And training should be provided for one member of the family who are engaged in manual scavenging to ensure that there are other livelihood opportunities created for them, there are other skill sets developed, and concessional loans should also be provided to such families. Also, the Supreme Court said that rupees 10 lakh should be paid as compensation for the people who have died while cleaning sewers. Now, in this recent judgment, that compensation amount has been increased to 30 lakh rupees. Also, there is a Namaste scheme by the government or National Action Plan for Mechanized Sanitation Ecosystem to ensure that the cleaning of sewers, there is no manual scavenging, rather it should be done through machines, etc. This scheme is jointly administered by the Ministry of Social Justice and Empowerment as well as the Ministry of Housing and Urban Affairs. Now, what does it say? What are the objectives under this? This is to ensure that there are zero fatalities for the sanitation workers when they are engaged in sanitation exercises. And the sanitation enterprises, they should be led by the self-help groups. There should be community involvement and mechanization should be there. There should be no direct contact with the fecal matter, that is human excrement should not be cleaned by hands. There should not be direct contact, and workers and families, they should be insured under health insurance schemes. For example, the Pradhan Mantri Jan Arogya Yojana, that is also to be done, and all social security schemes benefits should be there for the people who have been involved in manual scavenging. There should be skill development activities taken up, alternative livelihood opportunities should be created for them, counseling should be provided, and entrepreneurship training, etc. Such activities have to be taken up under Namaste scheme. Then capital subsidies up to rupees 5 lakh on the sanitation machinery costing up to 15 lakh should be provided, and interest subsidies are also provided on the loans to ensure that the cleaning is done through machines. And the training of the workers should be provided to the workers for the use of these machines also, and rupees 3000 is provided as stipend too under this scheme. Therefore, this works like a comprehensive umbrella scheme for ensuring that there is welfare for the people involved in manual scavenging. What are certain suggestions for this? One, we should have more data. That data should be there regarding outsourcing of the cleaning or sanitation related exercises, so that in future there is no manual scavenging which is resorted to, and there can be blacklisting of the companies which resort, or the organizations or people who resort to manual employment of people as manual scavengers, and thus implementation has to be done for the 2013 Act. And health and education should be the primary focus, and this can be done through Anganwadi centers also, the ground level institutions also. The state employment should be provided for the people who were involved since generations in the practice of manual scavenging, for example, the employment in Indian Railways, etc. And the technology should be used and startups should be promoted to create more livelihood opportunity in the sector. Now, next article is related to criminal investigation. The Supreme Court has in a recent case emphasized that we need to devise a consistent and dependable code of investigation. A code of investigation so that the guilty do not walk free on technicalities. There are a few legal provisions which are discussed in this article, and a few case laws will be discussing them too. This is important in GS2. Let us talk about first some legal provisions from the Indian Evidence Act and the Criminal Procedure Code. What does section 27 of the Indian Evidence Act say? It is related to how much of the information which is received from the accused may be proved in a court of law. If an accused is in the custody of police, then whatever he says in front of a police officer, that is not admissible in a court of law as evidence. But if he says something and after that information which is received by the police from the accused, there is a discovery of a material, there is a discovery of a fact, then that much information that is procured from the accused, that can be proved in a court of law. Now, therefore, section 27 lays down the conditions of admissibility of any fact which is discovered in consequence of information received from any person who is accused of any offense in the custody of a police officer. So these terms will be interpreted through a few subsequent case laws. Then section 100 of CRPC says that as per section 100 subclause 4, before making a search of a place, a police officer will call upon some witnesses, 2 or more independent and respectable inhabitants of the locality who will act like witnesses of that search operation. And as per subclause 5, a list of the things which are seized in the search operation will be prepared, and the list of the places also where they were found, that will also be prepared, and it will be prepared by the police officer, and this list of the seizure, etc. will be signed by the witnesses so that it is not disputed in a court of law. Police does not fabricate evidence. So these are both for protecting the accused so that the police does not extricate confession from an accused under pressure. Now, what do the judicial interpretations say? The recent case based upon this, which this article is based, Rajesh versus State of Madhya Pradesh. In this case, the court has observed that the person is not supposed to be considered as in police custody till he is formally arrested. But some previous case laws have said that a person can be considered as in police custody even if he is not arrested. For example, in Re Mansingh case in 1959, the court interpreted the word custody. The court said that custody does not necessarily mean detention or confinement. If there is a submission to custody by any action or words, that will also amount to police custody within the meaning of this section. But in this case, the court has not said so. Then also in Chotelal versus State of Uttar Pradesh, the court observed that an accused is in police custody within the meaning of this section when he is under surveillance of the police. He cannot break away from the company of the police, then he can be considered as in police custody within the meaning of this section. But in this case, the court has observed, in the recent case Rajesh versus State of Madhya Pradesh, the court has observed that the person cannot be treated to be in police custody unless he is formally arrested. Therefore, there is different interpretations by the judiciary itself. Another thing, the court here observed that the requirements of sections 100 subclause 4 and 100 subclause 5 of CRPC, they have to be met. The court took a literal interpretation of the section 100 of CRPC in the recent case of Rajesh versus MP. But in previous cases, for example, in Mushir Khan versus the State of Madhya Pradesh, the court had observed that if the discovery under section 27 is otherwise reliable, then its evidentiary value is not diluted just because the police did not complete the technical formalities which were supposed to be completed under sections 100 subclause 4 and 100 subclause 5 of CRPC. Now, what are some recommendations regarding this regard to ensure that there are reforms in the criminal investigation? One, the court has again highlighted the Malimat Committee recommendations and the Law Commission recommendations. Malimat Committee had recommended that investigation wing should be separated from the law and order wing in the police. But only 17 states in India have taken measures to separate the investigation functions from the law and order functions within the police department. Then Law Commission of India report 239 had recommended that police stations are understaffed, there should be more staff, and sufficient priority is not given to investigation of the crime. Investigation should be prioritized to ensure justice. And there is no periodic exercise to upgrade the skills of investigation. There should be more R&D, there should be more training to upgrade the skills of investigation. And it also observed that there should be a separation of investigation from the law and order duties which are done by the police. And the Prakash Singh case also gave the same guidelines regarding the separation of law and order functions from the investigation functions within the police department. Thank you.